Honorable Ikatari has attended several national and international conferences, workshops, seminars, and trainings in Europe, Asia, America, and Africa as a participant, panelist, speaker, and presenter. He's currently the Director and Chief Executive Regional Center for International Commercial and Arbitration in Lagos, Nigeria. Please join me in welcoming upstage for his keynote address, Honorable Wilfred Ikatari. Thank you.
The reason we're here is quite obvious. This selected, distinguished audience, it was intended and fashioned in this manner because we are the prime movers of your respective institution in relation to dispute resolution in both the national and international landscape, because you contributed to the growth. Where there's no growth, there's no development. I welcome specifically the speakers who, after my speech, will be on the high table to pilot and deposit the experience with us, individually and separately. I had the person introduce me in that form. Well, yes, I'm a person of many disciplines. I is in science, I is in law, I is in practicals too. I won't come here today epitomizes the fact that every one of us have at the back of our mind the need to move arbitration in the right direction, to the right shores, for efficiency and productivity in our various areas of engagement. There is the African tradition, not particularly associated with my people, except if you are in a place where you are a stranger and going to somebody's house who hosts you, wisdom requires that you know who that person is. And that one is to where, as I welcome you, the question you ask is, apart from the category that they talk about, it's this center. I think obviously, if the participants here were not selected, driven by the fact that they are the movers in their respective, the audience would have been larger than us. But we decided to do so, specifically recognizing their importance within the threshold of arbitration. Decisions that are taken here, awards that are taken here, that's when what many do not. The center can enforce the award, statutorily provided. And in enforcing the award, even if you consider it under the New York Convention, there is the additional empowerment that we can enforce it in any territory, either member state, non-member state. Okay. And because of our immunity and privileges, wherever we land to do so, we are covered. And the countries concerned, even if it's not a member, recognize our immunity status in that regard. So that is the strategic nature of this place. Then also, we have the capacity to make our own rules. They gave us the power to do it. And again, we are empowered to maintain a register of international arbitrators, expert witnesses, and even counsels that register with us. The reason is because we can recommend appointment to any part of the world where we are required to do. That is how internationalized the center is. To bring it to this point, let me put up something that the Office of the Attorney General made it. The enactment of the Regional Centers Act, R05, laws of the 2004, in no way makes the center an agency of the federal government. Indeed, the center is an international institution hosted by Nigeria. The enactment of the Act, therefore, is following Section 12 of the 1999 Constitution of Nigeria, which provides that international agreement or treaties entered by the government of Nigeria should be domesticated and incorporated into our laws before its enforcement. RCICAL is entitled to enjoy all privileges, immunities agreeable to similar international organizations. The government of Nigeria, therefore, does not interfere and will not interfere with the activities of the center. Federal government involvement in the activities of the center, therefore, is to enable the fulfillment of international obligations embodied in the Headquarters Agreement, signed in April 1999, and ALCO, under whose auspices the center operates. And RCICAL is established to cater for the arbitration and other judiciary needs of both private and public sectors of the economy, as well as countries in the region. The facilities for the arbitration at the center are made available to all nationalities globally, irrespective of whether the parties to such institution, international disputes, are nationals of member state or not. By this act, implementing the Headquarters Agreement of RCICAL, Lagos had become an international arbitration center. Why I want to conclude this welcome address with that is because it is important to realize that the federal government does not interfere here. I've not seen even a situation, not at all. They have not tried it and they can never try it, stated here. And you know the implication. Under customary international law, it is the practice of states that when a qualified officer of state, authority of state, deposits a statement, that statement under customary international law is binding on that very state. So, ladies and gentlemen, you're welcome to the center. I'm really grateful that you people gathered here today to exchange ideas and see which ways we can make arbitration better, friendly, and suitably to meet our needs and aspirations. And the fact that you people are here gives me a cause of joy and appreciation. In spite of your busy schedules, decide to find time. That's the honor. Remarkably, will never forgotten in the annal of history, as far as this center is concerned. I thank you all for giving me time, taking your time, and giving me your understanding.
Let me now turn to Natasha. Natasha, you are a well-qualified English barrister and an avoid. Is it an avoid for the politics? Avocat. Now, we see that arbitration is becoming increasingly international. By that I mean, you see where an arbitration will arise in a particular place, and then there will be the need for co-counseling a lot. So, from your own experience, how does the education and training help in ensuring that there is that full arbitration? Let's say there's an arbitration involving a French party, and of course, maybe the arbitration is half Nigerian issues. And then you see that there will be need for the French party to engage an advocate and at the same time engage the Nigerian council. But the training of the advocate and that of the regular counsel is different. Common law and civil law. So you that is a dual qualified barrister and advocate. What do you think how can both counsel collaborate effectively to meet the needs of their So I want to ask you a one question. First of all, there is this continuous need to balance legal strategy and business objective. And also, there is this factor of cost. So, give us your thoughts about, from your in-house experience, what can the company consider? What would a typical, let's situate it to the energy industry, because that's where what will the company consider in trying to balance legal strategy and business objective in choosing whether to use arbitration or litigation? And also, when it comes to the issue of cost, has there been any changes? For instance, companies in the energy industry now be open to funding solutions, cost-saving solutions, if I may, like third-party funding, to facilitate and access justice. So those are the two questions I want to answer. Thank you.
I think you've asked me about the same questions. And I'll start by saying that, well, you said it all. You started, I'll start by saying that the business of the company is not for dispute resolution. The business, particularly where I work upstream, is to produce and sell it and make some money. So, the legal department and dispute resolution projects, we are seen as the cost centers. We are not the fee earners. We support. And for us in the corporate world, we have KPIs, we have targets. Everything is the bottom line. Cost savings, cost optimization. So whatever you do, you must support the business in terms of even how you resolve disputes, even how you manage disputes, dispute pool, ensuring that even before it crystallizes into litigation or arbitration, we nip it at the bud. And we have a lot of strategies. So when you are in the corporate world, in the legal department of any in-house, particularly in the corporate setting, we are trained in such a way that everything is about the cost. We try as much as possible to support the business. Sometimes business commercial decisions may override legal decisions, legal opinions. We have to defer. We don't make the decision. We can escalate, we can advise. I'm sure I can say a lot of in-house people here agree with me. We can advise, but we don't make the decision. Highlight the risk. So in the context of the dispute resolution management, what do we do? How do we balance it? Like I said, we don't make the decisions. We highlight the risk. We bear it all, but we must support the business. So we must look for solutions within the ambit of the law. We must look for solutions that support that operation that is critical, that may make or mar the existence of the company. there's a particular drilling, project that is, just being planned. So what can you do as the in-house counsel in managing, the dispute resolution that may flow from it? You need to, in the first place, know the nuances associated with the various institutes that you may want to choose, or the arbitration law that you may want to choose. So in terms of legal strategy, I think I've touched on that. In terms of cost is a real big problem, particularly when you're talking about arbitration. But it's a thesis worthy, and I'm sure there's been several research projects on the cost of arbitration, how it is no longer delivering, how arbitration is no longer delivering on the promises of cost efficiency. But it's something to watch out for. What's the other question? Like I said, you asked me 10 questions. I don't even know if I've answered all of them.
So I talked about the fact that as a result of cost burden, we are beginning to see cost-effective solutions, for instance, like third-party funding. I want to know whether the companies, especially in the energy sector, are open to these solutions, because third-party funding is said to be a way of transforming a claim to a marketable asset to attract funding.
Okay. Well, I would say from the point of view of where I see having worked in the upstream oil and gas industry, yes, we complain about cost, but to a large extent, I can tell you that most companies in our group can manage the cost. They can pay at the end of the day. So the issue of third-party funding may actually not arise for upstream oil and gas company within Nigeria. However, our counterparts, our, opposing sides, maybe contractors, they sometimes have issues with payments. I have been involved in an arbitration proceedings that got aborted on the account of cost. And that is because the other party could not pay. We can pay, but we will not pay until you pay because you are the claimant. Unfortunately, that's it. Because in the first place, maybe it's a claim that we think should not even see the light of the day. So if you are bent on initiating arbitration, you should be able to pay for it. If you don't pay for it, we will not pay for it. If you pay, we will pay. So third-party funding for us is not an issue. But then let me wear the hat of a contractor that cannot pay. Now, it's now the purview, the prerogative of the in-house counsel to, justify to the management that there is a solution, third-party funding. Yes, we cannot pay, but there's this funding solution that can enable us resolve this dispute. That is a very difficult task, an onerous one considering where we are in our arbitration architecture in Nigeria. Why? You may get a good award. How do you enforce it? Confidentiality has been eroded. Finality has gone with the wind. I have read a number of research, written papers. I just got one from one of our senior advocates. It takes approximately 10 years for cases to go through from High Court to Court of Appeal to Supreme Court, because win or lose, one party is going to the court. That's what we have seen. And that is the rate of compliance with award is very low. So when you are justifying to the money, and everything is naira and kobo, dollar and cents to the management, okay, we cannot pay, but we have a very high chance of winning. Meanwhile, certainty is not guaranteed. But even if you can do your risk matrix and you say 90%, this is totally low risk, we are winning this. Merit done, merit assessment done, and this case is one that we are sure 90%, you can never say 100% anyway, 90% you are winning, and your management agrees with you, your principals agree with you. Then they are going to be asking you, okay, so how long does it take? You say maybe 2-3 years, time value of money. Maybe 2-3 years. Okay, so are you saying that after 2-3 years, you get, because you need to make justifications. Then they will now say, okay, well, the thing is, once the award is published, then maybe. So, and that's at the cost. So that's, my opinion. Are we matured yet for that? I know you have done one already, and I would like to hear your experience after the award. What's next? How do you justify to the management that who has, should I say, gone ahead on this third-party funding initiative, or even to the third-party funding fund provider? What happens when an award is challenged? Thank you. I'll stop there, so I'll just come talk.
Thank you very much. Thank you. Honorable Wilfred, I'm going to come to you now. In your very eminent keynote address, you mentioned some very important issues. First of all, you said the center has maintained its neutrality. Even though many people don't seem to be aware of this, most of the times when I advise clients, especially with maritime and energy industries, we always hear issues like, there is no truly neutral arbitration center to handle high value disputes. That is one of the complaints, especially our be they parties or co-counsel advising on the same transaction. We always hear issues as, there is no truly neutral arbitration center within the country to handle high value disputes. Now, but you have stated clearly and truly so that the center has maintained its independence since inception, even up to the enactment of the national arbitration policy. I want you to, and I also see that not just the center alone, but all of its counterparts in Hong Kong, in Cairo, in Nairobi, in Malaysia, the centers all around the world, as established under that treaty, multilateral treaty, they've maintained their independence. I want you to give us some of the success stories of how you've been able to achieve that, and then what would you advise parties and counsel going forward? Because, and why do you need to advise counsel? When we deal with our co-counsel abroad and we try to say, look, it is in the national interest that this dispute be seated in Nigeria, for instance. If your concern is that there is no truly neutral arbitration center, here is what was your advice? And how have you achieved this independence? That's what I want you to speak to. Thank you, sir.
Well, thank you so much. To begin with, the issue of neutrality is a part of the constitutive document, which I've already highlighted in address. You see, once you establish institution of this nature, it's not without a reason. The reason being that the Asian and African countries felt that it is important for disputes arising from international, intra-regional transactions should be resolved on the shores of our own region. And for that purpose, it is important, in conjunction with the CETRA, in the harmonization process of this law, to will into the process of modernization and bring those rules to bear in the dispute resolution ecosystem. And so, for a body to pursue the realization of that very goal, it is important that this center, like other sister centers, maintains a line of standard that can be leveraged on the global stage. We also know that international traders and those in commerce and all that investment, they don't have confidence in national institutions apart from the burden of businesses, time and money. There's also the need for a friendly environment where disputes can be resolved within a score time in a less expensive manner to meet the very needs and aspiration of the players, either traders, investors, and the like. So in that respect, it becomes compelling that an institution of this type, as we are here, be operationalized on the basis of well-defined core, tripod stand or triple stand of independence, neutrality, non-profit making, and something that can secure the integrity of the process. Like, for instance, it is designed in such a manner that we as a center that takes the administration, while also statutorily ensure that the composition of the tribunal meets a standard as agreed and as expected by the participants, or alternatively, where the participants do not spell certain things, which of course they ought to, the modified or institutionalized rules gives us the leeway to be able to do that. For instance, parties can agree to come to the center to resolve their disputes, yes. Parties can equally agree, as it is the practice, okay, we are going to appoint our own administrator, fine and good. In the institutionalization of that process, to maintain the integrity and neutrality, you know what? The rules allow a situation where if the parties did not specify or did not agree on the presiding arbitrator, or if even it's the sole arbitrator, we have two methods to follow. One, direct appointment by the center. Two, you use the list procedure. And the list procedure is to the effect that certain qualified arbitrators are listed and they are served on the parties for them to indicate their preference. It is out of that, when we get the list from the parties, we now know the common ones that have been agreed. And in that respect, whoever that we appoint there comes out as somebody that was agreed by the parties. Alternatively, if we look at it and the value of the claim is not that much, and they ask us to now appoint, we can now go to the list. We look according to what they prescribe. For instance, there are certain qualifications that they want to attach. That we want a person of so years of experience, so specialty, other specifications that they might give. What we have to do Like when they say, oh, party autonomy, this and that, and that. When they come up with those kind of things, what we have to do is to go in accordance with what they want. In doing so, we show in practical terms that we are not a party to the case. That's number one. Two, we are not conducting the case. We don't have any business conducting the case. The case is conducted by the tribunal. We are only there to assist. Like I remember, there was a time when a matter comes here, a very big arbitration, and the issue was issue of challenge to the arbitrators. The other party, they challenged the chair, and the other party again now challenged the other arbitrator. This other arbitrator, no, they challenge among themselves. They challenge the party A, then party B challenge that of party A. Party A challenge that of party B. So under the rules, they refer to the director.
For resolution?
Yes. The reason why it is like that is because we want to ensure efficiency in the process. If we now say, okay, we will gather a panel before they will come and look at it, it's time. So we don't have for that. It was referred to. I looked at it both ways and this and that. You know what? I found out that it is toxic. When there is a lot of confidence on the other side, and the other side should come ahead and say, oh, okay, we are not. I gave my reasons. Good thing I've been in the shadow of interpretation, so I just give my reasons. It was very obvious for all of them. And I said, well, in the circumstance that it were, let the two appointed give way and let exercise your own to appoint new ones, fresh appointment. But that which the center appointed was there in constant. And I remember there was a recent one too, they challenged. And when they did that challenge, they come to say, oh yes, but the arbitrator they appointed was based in London. He said, yes. That appointment cannot be touched. While the parties were so, you know how lawyers, they are challenging up and down, but they did not go to that of the presiding. So these are the issues where what we stand for. We don't want a party to be here before the center. Then they look behind to go and do what is unnecessary. That cannot happen here. Because we treat all nationalities and parties on equitable and equal basis. That is why customarily it is pronounced there that everything you see here is available to all nationalities on equitable and equal basis.
Thank you. Thank you very much. I will now give opportunity for the rest of the panelists to make their comments on the national arbitration policy, and that is very important. I had the privilege of being retained as the technical consultant to the National Arbitration Policy Committee, and I remember that in my capacity, I had to reach out to a number of arbitrators to make contributions, and Tom, you contributed a memo, and I know that the rest of you, esteemed panelists, you must have seen one form of government intervention to make the arbitral seat more attractive. So I believe that all of you are in a very good position to make comments of either a better way forward or a way, and by the way, the policy is still in the phase of consultations. By that I mean, it is operational. But if you see the policy document, it's stated clearly there that after 5 years, it will be reviewed and experiences will be shared. So this is a good time to get all of your thoughts. And of course, for Dr. Esa, she had mentioned to me before this event that the in-house community, they were not very happy about the fact that they were not consulted. In other words, there was no member or a representative of the in-house community on the National Arbitration Policy Committee. I said that is taken note of. And so in this event, I'm going to also hear your thoughts on what you think can be done better the next time. So I'm going to take all of your thoughts, beginning from Tom.
Great, thanks very much, Joseph. I think it's an important development. I think it's really good to have a roadmap as to where the jurisdiction wants to go in relation to international arbitration. If you read through the policy, it addresses the 7 Cs and other important issues that one needs to have in a jurisdiction as it tries to advance through arbitration. I think it's good that it gives a very important role to the center here, which, as we've heard from Honorable Wilfred, is neutral and has a lot of unique features that can drive the process forward. I think the provisions on the Nigerian Council and International working together are very important. Natasha has already addressed some of the reasons why it's important to have counsel from multiple jurisdictions. I think here it's a two-way street. To the extent international counsel are involved in issues where Nigerian law comes into play, they benefit from the expertise of local Nigerian counsel, but at the same time, it helps with capacity building for the Nigerian counsel as Nigeria and Nigerian parties find themselves in more and more international arbitrations.
Thank you very much.
Thanks very much. Yes, I agree with everything that Tom said. I think when an arbitral seat is trying to establish itself, the absolute key is confidence. Because parties, when they're choosing a seat, tend to be, I can only describe it as conservative. They're signing a contract which might go to a dispute in maybe 10, 20 years' time. And so therefore they want to know that there is predictability. And they're going to choose a seat where they feel that there is a structure in place. So I can only agree that it is a good thing to have this framework. That said, the other element of confidence is that people need to feel that they have a stake in the way that things have been decided and set out. So I think the point that you made about consultation is a key one as well.
I may have to add confidence as the 8th seat.
Thank you very much. Let me go to Louis before I come to Dr. Esen. Louis, I hope you heard the question. Hello, Louis, can you hear me?
Yeah, sorry, I was muted. Yes, I did hear the question. Here's a curveball for everybody, a jurisdiction that you wouldn't think has actually got its act together. It's Kazakhstan. And Kazakhstan has opened a center, created a set of arbitration rules, extremely complex and developed set of arbitration rules, and has procedures in place to deal with particularly challenges to arbitrators or contested applications that require, in inverted commas, a court. By court, I don't necessarily mean a state court, but some sort of independent judicial body. And what Kazakhstan has done, and I'm well aware of this because I'm advising on a case, what Kazakhstan has done has used, I will say, primarily English judges, but also some senior silks, senior KCs in London, to act as judges in challenges. My decision this morning that I read was rendered by Sir Jack Beatson, who used to sit in London's Court of Appeal judge, but giving his judgment in his capacity as judge of the effectively the Astana International Financial Centre for arbitration. And it gives both parties the certainty that nobody's going to get, as it were, stung by a biased, prejudiced local judge. It gives it's your 8th C, Tom. It's confidence that the party's going to have that the process is pretty impartially resolved, and that there are mechanisms in place that really do provide for control of the process from within the state, but by using, as I say, these effectively foreign judges. So that's my suggestion, that Nigeria looks askance, as it were. Fantastic that Wilbert's been able to establish the centre, but really to give people confidence that that somebody coming to Nigeria to arbitrate isn't going to be given second-class treatment. It's by having those sorts of mechanisms where decisions that fall within the track of the arbitration are taken ultimately by completely bipartisan adjudicators with decision-making experience. That's the other key factor. I mean, retired Court of Appeal judges are making a lot of money as arbitrators, as we know, but they're also doing this probably not so highly remunerated work in Kazakhstan, and I think it's a good lesson for lots of jurisdictions.
Okay.
Dubai, I know, has got a fantastic court as well. Singapore's got a fantastic court staffed with non-nationals. They're both, these are exemplars for certain.
Okay. Thank you very much, Louis. We still have a couple of grounds to cover, but because of time and because of the fact that we started late, I'm going to now come to the house and for a Q&A. Oh, sorry. Oh, I wanted to make the same mistake that the policy made. Yes, I mean, please, Dr. Esan, please, your own thoughts.
It was going to make the same mistake, but then I'm not going to allow it because I'm seated here. Exactly. Okay, so I took the pains. If you've seen the National Arbitration Policy, at the last page, you see a long list of all the members of the committee that put together the committee. So I took the pains of checking out everybody. Yes, we are in the digital age. Your footprints is everywhere. And I realized, yes, we have some in-house counsel, but from MDs, government enterprises, parastatals, but not one corporate counsel. And yet, you want to make Nigeria an attractive arbitration hub. Meanwhile, the bulk of the arbitration that takes place is between corporate entities. So, our voices definitely was not reflected in that policy. Perhaps if it was reflected, there might have been some introductions. There might have been some things that would have highlighted. It's a good thing that the National Arbitration Policy has come to be. At least it shows that we are seeking to put ourselves out there, and we are seeking to make the necessary changes regarding our arbitration infrastructure in Nigeria. And we are trying to sing the right type of songs, and but beyond the rhetorics, what about the reality? What are those things that is making arbitration not longer a viable dispute resolution option? I'll tell you, and I've said it at a different forum before, at a point we had to rethink the arbitration model in my company. And it's not only my company, it's about some other companies that I know. We had to go back, look at our model contract, and tweak and remove arbitration from it. So we need to deal with, not the main issues. Cost, that has not been dealt with. Judicial intervention, to some extent, has been touched on, but cost is very important. We need to have a matrix that works for us, and I'm glad that I'm a fellow of the Chartered Institute, the Chartered Institute of Arbitrators, because of this issue of cost, they've come up with a cost calculator that is attuned with our modern day realities, our Nigerian economic realities. Because in the past, what the arbitrators that have, presided over proceedings used was ICC scale of fees, and it used to be a lot of problem. It's not in tune with our economic realities. So beyond cost, so many other issues. And I'm glad that I'm here making this presentation right now. I'm hoping that those that have the ears of the promoters of the policy will let them know that corporate counsel, they are necessary. They have been underrepresented, but their voices are necessary for arbitration to take place and for Nigeria to be an arbitration hub. Our inputs, our insight, and we have a lot, I cannot tell you for free. We have a lot of insight that we can share and experiences that can help grow the arbitration ecosystem. Thank you.
Thank you very much. Thank you very much. At this point, I will call on a major stakeholder right here with us. During my time consulting at the National Arbitration Policy Committee, but first of all, let me say that the question and answer session is not limited to the National Arbitration Policy. It is open to everything that has been discussed prior, including if you want any of the panelists here to address any specific question that you have on any subject that they have discussed earlier. And then, but I'm now going to say that I remember during my time consulting for the National Arbitration Policy Committee, we had a wide range of people that we consulted, and part of the people, the major stakeholder that we consulted was the Chartered Institute. And today, the Chartered Institute is ably represented here by the chair of the Nigerian branch. They are a supporting organization in today's event. So she is a major stakeholder here. Please put your hands together for her. She was here early enough. And then we also have Ms. Bosa, and she's here too, a prominent member of the Chartered Institute. So, by the way, just to let you know that the Chartered Institute came here with a very strong delegation. Some of them have messaged me about different things that have happened that have disrupted their movements for today, but they are very strong here. And then she also, as she said, she is the chair of the Corporate Counsel Forum of the Chartered Institute. So I will call on the chair of the Chartered of Arbitrators. Please, can you give her the microphone to make her remarks? If she has any questions or comments, please put your hands together for her again.
Thank you very much. A pleasure to be here, and I thank you for the invitation. I think we're all in this together. Arbitration has come to stay in Nigeria. The next step is that Nigeria becomes a solid hub, not just in West Africa, Africa, and even for international arbitrations. I mean, there are things that we have to put in place, and we will continue. It's always a work in progress. Everywhere it's a work in progress. And we will continue to do what needs to be done to make Nigeria an attractive hub that would encourage people to make Nigeria the seat of their arbitrations. A country being a seat is not even just about arbitrations. It's also about economic development of the country. I always say that when a country is a good hub, a lot of people benefit from it, not just lawyers, not just arbitrators, business people, the tourism industry, the hotels. I mean, a lot of people benefit, the airlines, and so we need to keep working harder. I remember we were one of those who started training Rwanda in arbitration. That was about 15 years ago, and they have come so far in just 15 years. And I remember one of the things that, really blew my mind was that when we started flying Rwandair, the first page of the in-flight magazine was the Kigali International Arbitration Center. So So they were telling the whole world coming into Rwanda that we're serious about arbitration. And that's where we need to be going as well. I'm happy that the regional center were here today. The regional center has been around for decades, from when they were in Falomo to here. And, you know, I'm happy that things are really happening now in the regional center. And the regional center should stand at the same level with RCICAL in Cairo and Kuala Lumpur and the other ALCO places. And well done, sir. And we will be happy to keep working with you to take our own regional center to the same level, if not higher, than the other regional centers. There are things that we have to deal with. Costs. I mean, it's not just your company. Many people are saying we want to take out arbitration clauses from our contracts. If that happens, we're all in trouble. So we have to see what we can do. And one thing that the CIAB is now looking at is creating schemes for different industries and even saying you can cap the costs. Many people are not thinking about capping the costs in arbitration so that it's even more flexible, more affordable. We need each other. Corporate counsel, arbitrators, investors. We need to know, why are the investors not coming? I like what you said about the Dubai center, and those are things that we can emulate. We need to look at what we can do about costs, about appointment of arbitrators. These things are very important. The CIAB is working on these things, even though we're primarily an institute to train, but the CIAB generally, right from the headquarters, we now do appointments. We have a dispute appointment service and things like that. And so we're going to be looking at all these things. How can we drive it to the point where, I keep saying, we are a hub? Nigeria becomes a hub. The judiciary has to be affected. We haven't said much about the judiciary since we started. But to streamline the resolution of commercial disputes, to give us a solid role in enhancing ease of doing business, we cannot do without the judiciary. Because I have a matter where I gave an award. The award was challenged at the High Court. It was upheld. The one party went to the Court of Appeal. The Court of Appeal set it aside. And then the losing party went to the Supreme Court. The Supreme Court eventually upheld the award. But between the date I gave the award and when the Supreme Court upheld the award, guess what? 10 years. So that's why the ADR policy addresses the issue of the judiciary, but can do much more. And I'm happy that in 5 years, because one thing I was hoping is that the ADR policy would help to deal with the issue of arbitral awards going on such a long holiday in courts. You know, you give an award and then 10 years later. So nobody wants to come and do business like that. So I think there are still things that the ADR policy has to admit, things that we have to do. The judiciary is one key area that I just want to mention. And I mean, I know that right from the top, I know the Chief Justice of Nigeria is also interested in seeing that something is done about this. And I'm hoping, you know, with our Oga, that's what we call the boss, you know, with all of them, I believe that over time, and not a long time, we'll begin to see things happening in the arbitral space in Nigeria. Thank you very much.
Thank you. I'll now open the floor for questions and answers. Any other member of the panel that has a closing word? Any questions from the panelists? I mean, from the audience? Any issue that you want to ask regarding any of the issues or subjects matter mentioned in the course of the panel presentations? No questions? Yes? Okay. Oh, we have a question. Please, can you hand the mic to? Okay. Yeah, sure. 2 questions. Yeah. Go ahead.
Thank you very much. My name is Hawa Usman. I have two questions actually, and thank you for inviting me to attend this. I think this is very important and timely. My first question is quite apart from the issue of the cost that has been highlighted. The issue of enforcement and compliance of the arbitral award has also been highlighted as a serious issue. So I'm asking if the panelists now, especially from other jurisdictions, are there some practical strategies that you feel that we could adopt to ensure that there is more effective and timely compliance in terms of the arbitral awards in Nigeria, especially in the face of resistance or delay tactics by losing parties? And my second question is on the issue of mediation. Do you think that mediation could play a complementary role in enhancing the ease of doing business, as it were? Thank you.
Thank you very much. I would throw that question to all of the panelists. I will just ask that each panelist intervention of each panelist be limited to 2 minutes so that we can meet up with our time. Most of our panelists, they have already booked their flights, but of course they had to make that sacrifice to be here today. So please, I will start with Tom.
So I think those are two very good questions. And the first question sort of ties into the comments that we heard a couple minutes ago. I think in terms of strengthening, speeding up the enforcement process, one approach that we've seen, I think, in Mauritius is that Mauritius established a special chamber of its Supreme Court. So the Supreme Court is the highest court in Mauritius to deal with all arbitration-related court proceedings, so annulment actions, enforcement actions. It's a relatively small chamber. The judges receive training in arbitration, and they know the basic principles, and that speeds up the process significantly. And onshore UAE, under the federal arbitration law, got sort of halfway there. The supervisory court is the court of appeal, so you cut out the court of first instance. Court of appeal is still subject to appeal to the Court of Cassation. So that's one way to speed it up. In the UAE, a lot of people enforce foreign awards through the conduit, we call it conduit jurisdiction of the DIFC courts. So they'll get the foreign award recognized as a judgment by the DIFC courts, and then it's easier, generally speaking, to enforce that DIFC court judgment in onshore UAE. So there are different mechanisms for doing that. On the mediation question, the short answer is yes. I think mediation can be very complementary to arbitration. The success rates in reaching a settlement are quite high in mediation, and I think it's something that needs to be looked at as one of the precursor steps to arbitration by parties. I'd be interested to hear what Nike, the user, has to say on that.
We'll go on to Natasha, and then after that we call on Louis.
Thanks very much. I'll be brief as well. I think those are two very good questions. I think they're also two connected questions, and I'll explain why. I think there is no easy answer to the problem of how to enforce an arbitral award. And it's not just a question for Nigeria, it's a global problem. And very often my clients, when they come to me at the very beginning of an arbitral process, it's the first question they ask, well, when I get the bit of paper, am I going to be able to get some money out of it? And the answer to that is always very nuanced, and there are always steps that you can take. As Thomas said, there are steps that jurisdictions can take to make it as quick a process as possible. But very often, my view is that you need to look at arbitration and enforcement as an ongoing process in which the goal is ideally to see if you can't reach a resolution between the parties. So when you receive your arbitral award, the first thing you should be doing is persuasion, trying to see if you can't get the other party to recognize and conform voluntarily with the award. I fully recognize that that's not always possible, but it is a part of what can be done to facilitate enforcement, and that's where it ties into mediation. I think negotiation and alternative ways of encouraging discussions between the parties so that the award is recognized is important, not just at the outset of the process, but also even when you have received your arbitral award and you're thinking about how to enforce it.
Thank you very much. Louis, I'll call on you now before I go to the director. Louis, you are one of the enforcement specialists, so your expertise is now being called upon to advise some of the parties who are here and, of course, the co-counsels, potential co-counsels. So can we hear your thoughts on this question? Louis, can you hear me?
Yeah, can you hear me?
Yes, we can hear you. Go ahead.
I heard everything, including the contributions and in particular, obviously, the question, which was, all very well about costs, but how are we going to enforce and what's the worth if you can't? Is this sort of hidden message behind the question? I'll start with the horror story. I have a client for whom I obtained an award in 2003, 22 years ago, and we are still enforcing that award in Tanzania 22 years later. We've gone through 4 rounds of court of appeals, where we've finally got to the point where we think we're going to get finally some enforcement measure. Tanzania ratified the New York Convention, signed up to in 1964, one of the first African states to do so. The original signatories, and there were about 10 or 11 to the New York Convention, included, I think from memory, 3 African states: Egypt, Morocco, and Syria. Might have been 1 or 2 others. Very swiftly followed by Central African Republic, Madagascar, and others, and then Tanzania in 1964. Nigeria, I think I'm right in saying 1970, but somebody in the room who's got Google with them will correct me. Enforcement, if you have a recalcitrant respondent who does not want to pay, can take decades. And there's no easy way around it. There are safe enforcement jurisdictions. And by safe, I mean relatively swift. The United States, particularly the Southern District in New York, is an excellent enforcement venue. Switzerland is an excellent enforcement venue. Sweden and the Scandinavian states are very, very good. I'm excluding England because it's always been a good one. But France and Germany tend to be very rapid, and lots of the places have established, as Tom was saying, that they've established a particular court that will deal with that sort of enforcement, a specific chamber, and that does really speed things up. But if you are enforcing in Afghanistan, which is a signatory to the New York Convention, good luck. It might take a while if you have a recalcitrant respondent. Choose your contracting parties carefully is the only answer I can give to that. Because if you are enforcing against a party whose only assets are in a state which is difficult to enforce, that's the problem. No easy answer.
Okay, thank you very much. So 2 takeaways from Louis's answer. The first is that our chair, Mr. Degwebe, your experience is better. Yours is 10 years. He 20 years and still no enforcement. So, and then the second takeaway for me is that in negotiating your contract, ask your contracting party, where are all your assets located? Yes, so that at least you have an idea of where you are looking for towards enforcement from the onset. Okay, so.
I would like to add that one of the things you need to do when a dispute crystallizes is knowing when you should not use good money to chase bad, knowing when to jettison your arbitration clause and do something else, negotiate, mediate, or even go to court. You know, you must know that. We've had experiences where even in asset tracing and even trying to pin down the contractor that took some money. We had engaged a law firm in Germany, and you know, we're trying to trace the contractor who was in Germany at one point in Italy. We were going everywhere. He was responding at some time. He was meant to supply some tubulars, and he cheated me out of a German trip. I got a visa, but at a point we had to just cut it off because we knew that even if we had gone ahead with the arbitration, whether or not he showed up or not, we would have gone ahead. But at the end of the day, where are you going to enforce it? Where are the assets? Was going to be using good money to chase bad. So you must know. That's one of the things as a corporate counsel. You must have such skills. Well, with respect to cost, again, it's also important, like I said, that you know the business. You know who you're dealing with, and you make the necessary judgment at the right time. One other thing I would like to say is that enforcement in Nigeria, even with pro arbitration courts, we have some peculiarities, that just makes it impossible to get a fast, expedited outcome. If unfortunately, and this is some of the pains that we bear as corporate counsel, if unfortunately you need to enforce an award in an election year, you understand, and you are going and the court is on national assignment, you keep going adjourned because the court is on national assignment, or there is a judiciary strike, or for one thing or the other, insistent adjournment. It's just peculiar to us. But then, these are things that can be dealt with, and I'm hoping that at one point or the other, we will get there. Thank you.
Thank you very much, Dr. Esa. Your thoughts are very insightful. We'll now call on Honorable Wilfred. Both the headquarters agreement and the RCICAL Act made no mistake about, Daniel Wilmot is here. Please put your hands together for him. He was able to finish his record time. Yes, he was able to finish it in record time. Director, may I seek your kind permission to hear from Daniel? Now, and good enough, Daniel, we are talking about enforcement. And he is one of the specialists, of course, in that area. I say so because apart from the fact that he and I will discuss on enforcement strategies extensively, he's been able to do it at record speed. And also, I need to mention that Daniel is not just a British citizen. He also has a Seychelles passport. He was actually born in the Seychelles. So he knows Africa very well. He knows where to find the assets. So Daniel, please, I'll call on you. If that's the only thing we hear from you today, that will be enough. Please give us enforcement strategy. Somebody had asked a question about how enforcement can be done faster, what to do to trace assets, So please, let's hear from you.
Thank you, Joseph. Thank you for bearing with me. First of all, Mr. Justice Robin Knowles of P&ID fame was kind. Let me just put it at that. I shan't say any more. But apologies for not being able to join you until now. In enforcement, it's an interesting area. For me, it is as much commercial and strategic as it is legal. Because what do we really mean by enforcement? We mean to monetize a judgment or award in our favor, essentially, if we are talking about a monetary award or judgment, of course. Sometimes it doesn't require one to think about all of the assets which added together get you to the financial number that you need. Sometimes one need only think about that one asset that your opponent really prizes, really cares about. And we've seen enforcement strategies, for example, premised on seizing a presidential plane, for example, which, funny enough, suddenly unlocks the deadlock of resolving the enforcement issue. So I think my first point is, don't just think about things through the legal prism, think about them through a commercial and strategic prism. Thereafter, obviously the law matters. You are looking at jurisdictions that are probably not going to want to reopen the findings on liability and quantum. Typically there you're looking at jurisdictions that might respect, perhaps whether under a guise of comity or a convention obligation, the role that an enforcement court plays. I think that's a very important consideration before you start issuing enforcement proceedings. And then, of course, you need to do your due diligence. And there are a number of agencies that are available to assist. They will advertise their wares very happily as soon as you pick up the phone to them. They are typically called asset tracers. There are those who are pitch themselves as expert in a particular jurisdiction or otherwise. They have their role, but they don't have a magic wand. They have access to precisely the same information that you have access to. There is no particular entitlement that they have been bestowed by a particular country to lift the lid on accounts or asset registers or otherwise that you don't have access to. So of course, recognizing when one is not an expert in a field is important and you seek the assistance that you need, but sometimes it's amazing what a stiff cup of coffee and Google will get you in terms of information that you need. Understanding accounts, public disclosures, filings, access to records, that knowledge in and of itself can get you quite far, in my experience. Perhaps I'll stop there, but I hope that answers the question at least, because I didn't actually hear the question, but there we are.
So we'll go to Honorable Wilfred, and then we'll take the second question from you, madam.
What am I answering now?
Well, part of what you said in your presentation was that the Regional Act empowers the regional center to assist with enforcement. So by that, I take you as one of the specialists in enforcement. So let's hear your word.
Yes. As rightly identified, enforcement is one aspect of arbitration that, strictly speaking, has discouraged quite a lot when it comes to how to recover what you have been awarded. There are obstacles. But now, looking at the convention, the New York Convention stipulated certain areas for which you can be able to see how you can move forward in the course of the enforcement. There are limited areas that it has provided. But beyond that, there are national laws too that are there in place. And again, you need to also understand the particular country's legal order, or do I say the court system. It's important. Like, for instance, in Nigeria, we have what I used to call graduated judicial system. From customary to High Court, Federal High Court, State High Court, Court of Appeal. And when parties tend to shift away, it's because of the long list of how it goes all this up and down. And so, when we are doing the policy, which was a prime factor in that policy, we faced with the question of how to enforce award in a system where the courts are so arranged from federal high court to state high court. Where do we actually start if you want to enforce? It is my view that in a country as Nigeria, there is no need for you to follow all along from the lower part, federal high court, they will take it to court of appeal, this and that. It wastes a lot of time. So it was my view when we are making that aspect of it. But unfortunately, many did not see with me. But my view was that anything enforcement should go to the Supreme Court straight away. The reason is that it causes the situation of aligned councils, or those of them that may not benefit from it, to go against the interests of those who will benefit from it. In other words, if they start at the Supreme Court, the issue of moving from federal high court with the delay tactics here and there, whether something is useful, not useful, to the court of appeal, it will take 12, 10, 15 years. So there's no need for all that. The best thing is to make it in the policy that there must be a division in the Supreme Court for which enforcement awards can go there, finalize there, and that is all. No need to follow the order. That was my view. But it was later, some said, okay, you should start at the Court of Appeal. If you start at Court of Appeal, it falls to the same circle because they must delay it and they must also go. They say, oh, that the judgment, the award is not up to, it's like a federal high court. I said, yes. If you're looking at it, you must understand that this award is not emanating from our regular judicial system. This is commercial thing, time and money. That is it. So that is eventually where we stand for. But all the same, given the current arbitration policy, it is because of that they said, okay, let's form an awareness committee, which I've already written to the federal government to constitute. That committee is to put up a framework of a policy mechanism where the courts would be enlightened to the effect of how they will give preference to within a time frame. Of course, it's stated there, but we have to go further. That was a diluted version. You have to go further to see that whoever that is filing a matter for enforcement must be given attention within a stipulated period. So that is where we are now. But the federal government is here to respond with that committee. And I believe in doing so, it will enhance a lot of things. And losing the areas that entanglement might likely cause delay. That is it.
Thank you very much. Please, before going to Madam to ask a question, I just want to mention that under the policy, the courts, the enforcement court has been given a mandate to resolve enforcement issues. That is the first instance court within 60 days. And so parties need to be aware, because most of the time, even from my experience, I'm handling one of the intra-Africa enforcements now where a Kenyan entity having an award against the government of Rwanda actually instructed me, and that has been ongoing. So most of the times I've observed that it is how persuasive you are before the judge that makes the judge to take into cognizance the provisions of the law. So the National Arbitration Policy provides that enforcement proceedings should be heard and determined within 60 days. And then appeals arising from those enforcement proceedings at the Court of Appeal should be heard and determined within 270 days. So it's important that parties are aware and counsel also is aware, because how the enforcement court gives you priority based on how convincing and persuasive you are. I just need to mention that. Okay, can we go to her now for a question?
Thank you. You can go ahead.
Good afternoon, everyone. My name is Justina Lewa. So just taking it from there before I ask my question. Someone like me, I'm just hearing this for the first time. Are people aware of this, your policy? And do they know that they have a time frame within which to resolve these issues? Because if we're talking ease of doing business in Nigeria, arbitration is supposed to be one of the fastest ways. But with what I have heard here today, there are stumbling blocks, and so it is neither here nor there. And not to talk of even the costs. Even though the Institute has taken a step with the cost calculator, but that calculator is calculating a lot of heavy sums that nobody is looking at or using it. So Institute, maybe you should try to do something about it, because one, the claimant, by the time you come up with the cost, even if the claimant is ready to go with it, you will find out that the respondent is not answering you, and the claimant will come back to say, it means that I'm going to also take on the cost from the side of the respondent. I won't be able to do this. So can we negotiate further? So you keep the calculator, where is it now? You keep going back and forth. So Institute, look at that calculator. How can you help? Then two, the judges, they usually have a yearly conference. What have we done to bring to their knowledge that they are actually a stumbling block? You may not say it to them like this, but can you incorporate arbitration training and the need for them to understand that if they go along with the business community, that they will be helping a lot and they will be cleansing the image of Nigeria worldwide.
Okay. Thank you.
Then the last one is what Nike has said, this third-party funding. Yes, okay, you get the third-party funding. Then they set aside the award. What happens to the funder?
Okay, thank you very much. Thank you very much. I will hand over the microphone to the director to answer some of your questions, but I just want to make a few comments. And I mentioned earlier that the counsel you retain in your arbitration is very, very crucial, because it is the counsel that knows the provision of the law to exploit that gives you a strong position. Even if at the end of the day, there's an award and you want to negotiate with the other party to pay something, even if it's not all, or you want to actually do an enforcement proceedings, it's very important. This provision I just read to you now is because I'm aware of it. And this event, the purpose of this event is to make more people to become aware of it. Then I also want to mention that the arbitration I did that we had to bring in a third-party funder was administered by the center. And why was the arbitrator open to the third-party funding? Why was the arbitrator open? It's because the respondents in the arbitration made it known from the very inception that they were not interested in paying. So when we brought the third-party funding arrangement, we served it on the arbitrator, we served it on the other party. There were no grounds of objection, because you have already said you are not going to oppose, you are not going to pay. How then do you expect the claimant to fund the arbitration? From where? So therefore, when you bring the those kind of arrangement, if the counsel knows the provision of the law clearly, it helps. Then in the other matter I told you I'm doing at the Federal High Court for the Kenyan entity, I had to point out to my lord, look, this is a foreign arbitration. And this is from Africa, right here in Africa. We have to make our jurisdiction to make us look like we are actually serious with arbitration. So I pointed the judge to the policy. Look, the policy says this is an enforcement proceedings. It has to be resolved within 60 days. Even if you don't want to do it strictly within 60 days, give it priority, being that it is a foreign arbitral award that is being enforced in Nigeria. I mean, that is more or less unheard of. So the judge considered it, and he saw reason. So the counsel, the knowledge of the knowledge that the counsel has of the law helps a lot. So that's very important. As in-house counsel, you have to be sure that the counsel you are retaining for your arbitration or your arbitral award enforcement proceedings knows the law very well. I will hand over to the director at this point.
Taking it from there, that is why we are here. When we say coordinate and assist and all that, a lot of things goes with it. You see, we are a council. We have a culture universal, but I know here in Nigeria. You see, the child that listens to the voice of the father don't make common errors. You see, there are people who read the law, for which we have read and we are on this side. It is better and profitable to reach out. I remember over time, there are a lot, even some of them are seated here. They will reach out to the center because we are here to advise. There are issues we advise. Third party funding, when they were inserting in the AMA, like I said, they were pushing the session out. So I kept quiet. I'm not a sheriff in town. But I know very well that anyhow they do it, the center stand where it is. They cannot alter it. At the end of the day, when they heard, oh, it is a third-party funding, they went and put it in. It's good. Said we are making progress. But the question is, what other safeguards you put around in place to that third party? You just carry it and put it there? No. Okay, so when it comes to enforcement, what we know, we apply our own rules. We apply our own rules to say, look, if you want to fund, you must disclose to us who is funding. The reason is because we don't want a situation where you stand to fund, then you use that one as a venue to influence the integrity of the process. That we cannot compromise. So you must tell us. Disclose to us how you get the money and who is paying what to us, who you are. Why are you funding it? You must state it to us because it must be in our records. Without which we cannot admit it. Because the rules say for anything it is that will be included in the award, it must be the director. So if I don't submit a third party funding, it cannot be reflected. That is the truth about it. This is a part of maintaining the process. On the other side, when you talk about the issue of training the judges, like I said, one thing I discovered is here, you see, most practitioners that represent clients here, they always think that the arbitration environment is the same thing in the statutory courts. They don't bother at all. But I remember one client, a senior advocate, who called up me and seek to know. And I pointed out, look, all that you do there, the jigger and the jiggernaut that you do there, they are not applicable here. The strict law of evidence and all this and that, all these things are not applicable here. And when you're presenting your case, present your case in a simplistic manner. Because what is wanted here is reasoning. Not structured on evidence and this and that. Yes. So he told me openly that yes, he has been in litigation over the years, senior, but he did not. But the enlightenment he got from us is very important. The same thing to judges. Once this arbitration is in place now, like I have asked the Office of the Attorney General to see into the constitution of the Public Training Awareness Committee, which will definitely bring the private sector into being, then we know what to do. It is very, very important and cardinal to bring the judges into terms, in the same loop with what arbitration entails, so that in a situation where it is required for them to exercise, they will do so within time frame and allow the enforcement process to go smoothly. May I just leave it here for some other time? Thank you.
Okay, thank you very much. With that, we'll bring the panel session to a close, and we'll call on the director to give the vote of thanks. And I see some envelopes here. I believe that there's some presentations to be done by the director, so I'll call on the director to give his vote of thanks and to present the whatever it is in the envelope and explain it. Thank you. Director.
Well. Don't look. Don't look. Don't look here. And has been a counsel to the center too when he was there at the Nigerian Law School as a lecturer. And that is Honorable Justice Nelson Obuanya. It's good to see you. It's good to see you. Yes. He has been our defense counsel. Those of them that will take us to court for doing our statutory functions. Well, you see, something that is good is worth doing well. If you live in doubt, it is doubt that will control your thought and deprive you of your capacity or competence to take charge of situations. When this invitation moved that, okay, we want to examine ease of doing business here, streamlining arbitration, we are trying to envisage a situation where we see the need for arbitration policy, international conventions, national law, national policy, how we can bring all these things together in order to do a business that will be beneficial to all stakeholders. The gentle men seated here, they say in the field of law, no women, no. So all are gentlemen. All are gentlemen. They honored the center. Immediately that invitation was mentioned, they honored the center in a manner that baffles me. I do not expect. And that is why it gives me a lot of delight. And I felt, well, the center has come off stage. This center is a principal factor in the current national arbitration policy. No two ways about it. Because over the years seated here, I did a comparative study of different countries and their arbitration laws and their policies. And I find it necessary for Nigeria to do it. But they resisted until the PINID burst. It is then they called upon. And like Dr. Esau said, if they had consulted us in the composition, definitely you people would have been in the process. But they did not. They chose to do it. I raised that issue, but it's good. It's ongoing. Today, we have come this far. And in order to tell the world, the doubting Thomases, that in this, our panel, those who honor us, we've gotten them. But now with the arbitration policy, if you are coming here to come and register, $1,000. Don't come and even open your mouth. The reason is because the center now advises federal government on issues of appointment of arbitration, council, and the like, both at state and federal level, including our own very ones here and the international breed. And so if you are registered here, you have the advantage. That is what it is. Quote me anywhere, and I will tell you what it is. So today, we're happy to honor those who have honored us. And the first person that they presented to me, you stay there. The first person they presented to me is Thomas Schneider. Take your stand. Let me see. Yes. Come. Hold the microphone for me. Hold the microphone for me. Put it where my mouth. Because, do we face this way? Yes, sir. Oh, very good. This is certificate of registration on the International Panel of Arbitrators and Expert Witnesses, presented to you, Thomas Snyder. The Regional Center for International Commercial Arbitration, RCICAL, has the honor to formally register you, Thomas Snyder, partner and head of arbitration, Charles Russell, Specially, Dubai, UAE, on the register of the International Panel of Arbitration and Expert Witnesses. This certificate affords the opportunity to be engaged upon appointment by the center as an arbitrator, counsel, or expert witness in any reference or relevant matter, be it international or domestic, before this institution or as an appointing authority. By virtue of Section 16 of the Diplomatic Immunities and Privileges Order 2001, you enjoy such immunities and privileges applicable to the arbitrator, counsel, and expert witnesses on the register of the center. This 14th day of this 4th day of July 2025, under the signature and seal of the center. I present this to you. For having honored us, we also honor you. Thank you. Thank you. Thank you. Next, where is the voice? Give me voice. Next is Natasha Peter. Today, we honor you as you honored us. This institution is great. Just as you have heard me read, what I have read for the other party applies to you. And I will say that by virtue of Section 6 of our diplomatic immunities and privileges of this center, and the fact that we have honored you and formally registered you here in this center, you enjoy such privileges at all times, be national or international. We can call upon you to preside over a matter anywhere in the world with these privileges given to you. Thank you. I call on Daniel Wilmot. The man that was conducting two, one here, one in Lagos here, one in London at the same time. In Nigeria, we say, make you rest now. Give other people something too. You did here, you did here. Anyway, so haven't heard what we presented to the rest? The same thing applies to you. You've honored us, you made us proud, and you made Nigeria proud and the region. For this, we have formally registered you and certificated you to enjoy all privileges and immunities as an arbitrator, as counsel, and expert witness. Anytime we can call upon you for a matter either international or domestic or any relevant matter at all. This is the certificate evidencing the registration. Oh, yes. So this one is online. Oh. The one that the wife said, no, I'm going to Spain, not Lagos, for Portugal. Sir, Leos Fonery, you are the King Counsel that has honored us. You would have been here in person, but all the same, you make it available for you to talk with us, contribute. You show keen interest from the beginning. So that honor, we are proudly honoring you in the same instance to say, because you've given us honor, we too honor you. We have presented a certificate of registration on the panel of international arbitrators and expert witnesses and counsel. And by virtue of that, all immunities and privileges associated with it, granted to this center, is also extended to you by virtue of your formal registration on the register of this center. Accept it, and we thank you for being with us. Thank you, sir.
Thank you.
Yes.
Can I make an announcement? I think that Daniel should bring it back in his luggage, and I will swap it for the shirt that he lent me last year when I got a wine stain on mine.
Yes.
It won't cost you much, Louis.
Yes.
The usual, Daniel, in the usual location.
Dr. Adenike Eson, happy to see you in the first instance. I think this is the very first time we're meeting on one-to-one. And when the invitation was extended to you, you surrendered every other thing and said, this is a priority. That honor will go without being properly documented as we take notice of that. You've shown your interest, you've shown your appreciation, and you show your willingness, readiness to always work with the center. So in the course of promoting the center, we have a way to promote you. And for that reason, we register you formally on the International Panel of Arbitrators and Expert Witnesses, as ordained by law. Today, we present to you this certificate of registration, which, like you've heard from others, entitles you to be called upon. In any relevant matter, we know that you can competently do it, because we trust in your competence and expertise. And also, we believe that having not even been registered, you are promoting this place. So now that you are registered, it's even more. All diplomatic privileges and immunities ever we ask you, and at all times, you are on this panel, and you remain on this panel. We thank you so much. This is
Okay, I want to use this opportunity to thank you. When I accepted to speak here, I didn't know this was coming, and this is a wonderful surprise. And I'm here because it was taught that a corporate counsel's voice should be heard. And now who enabled that? The chair of the Nigerian branch of the Chartered Institute of Arbitrators. I want to say thank you again, ma. This certificate, I cannot take it alone. She's an enabler. So I am coming to take our own certificate of registration. I'm only down the road. I've told you before. So next week, please prepare one for my madam here. She's the one that made it possible for me to come and sit here and share my insights. Thank you very much, sir. I'm grateful.
Thank you. Well noted. When we were at the ICC, he said, oh, director, I'm coming there. I'm coming there. I was so excited. I said, okay, you repeat that again. And before I know, he's here. So, it's well said, well noted, well accepted. And we have no choice than to implement it. Thank you so much. I think on this note, do I still have to do any other thing? Oh, yes. Oh, the able young. You see, these days, we When I was in the village, I was smaller than this. And we went there. As we were building the pond, all the elders line up, they clear somewhere, line up and relax. And when we are finished, it was about 3 days building that pond, of course, very big. And all the time we are doing, they are just there discussing, some of them knocking their, this thing, taking their yes, no. So when we finished everything, and they selected and sorted the fishes and all that, they selected the big ones to cook. So when they do that, one of them began to ask, but we that were doing the work, we have not seen better thing. One of them said, look, wait. These days, the work will kill the young ones, but the meal will kill us, the elders. So it's something else. It's not always like that. Once you work hard, you deserve to be well cared for. This young man here is a piloter of so many things. He came in, asked so many questions, did so many things that I see beyond his age. Is faster than his age. In arbitration, is faster than his age. And he always sought to know, what of this? What is this? He will ask questions. And those questions are not questions that just for ordinary sake of. Ones that will take you time to make him understand. Today, when you talk about this center, the understanding in heart of this center is in depth, because he humble himself. When he travel out of the country, he comes within, he handle this matter, he will come and ask, and I will explain. A lot of this happen. And that was why during the national arbitration policy was made be there. Because he's one of them that took this thing out. He has done a lot of something. And if a young man, vibrant, qualified, and exhibits a sense of not only commitment, but competence, it wonders me. Sometimes when you ask even my seniors, what is competence? They drag you into the field of academic qualification, this, that. No. Competence has to do the innate qualities of the mind, to be able to explore all areas of skill, profession, academic, this, that, to use the human resources to achieve result. That is competence for you. You can even insult an arbitrator because he's competent. He knows what he's doing. He knows the onion. He's going on because he's going to manage recalcitrancy together with those of the, all those are the elements that make up the complexity of human behavior. So your ability to take that one into context, control it and use it together with the experience and your skill to achieve result is very, yes. And so today, we also honor you because he that has done well must be appreciated. We felt that, it's reserved for, if you know in this place, I've been doing things people don't know. I've always appointed young people to arbitration here. I appointed women to arbitration here. Very many young people. Some don't even have the experience. I bring the experience has to start from a day. Everybody experience. If they don't start from somewhere, will the experience come? Then it means because they have no experience, they are thrown aside. No. I don't do that. That is with anything that avoids my discretion, I do it. And I stand to attest to that. The volume of cases are there. Young people, I experience them. Come and handle it. That is it. Because it has to start from somewhere. We say their own truth, they go postpone, like I'm a pastor now, they say, my own heaven, but no, I'm on earth. Let me say the one here first. Wait the other one. So my brother, thank you so much for what you've done to this place. And we honor you to have come in a gentle manner, meeky, and you gain a lot. And for that reason, we register you. That enjoy our diplomatic privileges too. In the appointment, this is the certificate.
Thank you very much, everyone. I see that a lot of people came after the panel session ended or halfway. I believe that there is a recording of this, which we'll be able to view much later. We have come to the end of this program, but before we leave, we're going to have a group photograph. We also will have our lunch after the group photograph, so please stay behind to enjoy the lunch.